Yes, Registrar, you can call the case.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Dominica. Delivery of judgment in CCJ Appeal, DMCV number 2 of 2018, between David George and Albert Guye. Today's panel comprised Mr. Justice Witt, Madam Justice Rochnut Lee, and Mr. Justice Burgess. Please state your appearances for the court.
If it pleases the court, Gina Guye Monroe, appearing on behalf of the appellant.
And
May it please your lordships, Michael Bruni, appearing with Miss Lisa De Freitas on behalf of the respondent.
okay, thank you very much. In this case, the court has come to a majority decision, 3-2. I will not read the whole judgment, but I will give you a summary. The main judgment is written by the President of the court in his own name and on behalf of myself and Justice Rochnut Lee, who also wrote a separate judgment. And there are two dissenting opinions from Justice Anderson and Justice Burgess. The text that I'm reading is, of course, not to be intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. Those reasons can only be found in the judgment itself. This matter concerns a dispute as to ownership of a strip of land in the Pottersville housing scheme area in Rosso, Dominica. The appellant, Mr. George, was the occupier of the strip, which formed part of a larger parcel of land, of which the respondent, Mr. Guye, was the registered proprietor. Mr. Guye purchased this land in 1995. A year later, a certificate of title was issued to him in keeping with the provisions of the Title by Registration Act. It was not disputed that Mr. George and his father had been in occupation of the strip of land for over 12 years. In 2007, Mr. Guye filed an action claiming a right to regain possession of the disputed strip of land. Mr. George's defense to Mr. Guye's claim was that under the provisions of the Real Property Limitation Act, the title of Mr. Guye had been extinguished. Mr. George also contended that even if he, Mr. George, could not maintain an action against Mr. Guye to assert ownership of the strip of land, he was entitled to resist Guy's claim for recovery of possession, given his long and continuous possession of the land. Mr. Guy's claim to recover possession was based on his certificate of title to the land, which under the TRA, the Title by Registration Act, rendered his title to the land indefeasible. Thus, it was argued that an adverse possessor, such as Mr. George, could not defeat the ownership rights of a registered certificate holder unless the adverse possessor complied with certain procedural steps set out in Section 33 of the TRA. It was not disputed that Mr. George did not comply with those steps under Section 33. Both the trial judge and the Court of Appeal accepted Mr. Guy's argument, and Mr. George appealed to this court. On appeal to this court, the court was called upon to consider and interpret the relevant provisions of the TRA and the Limitation Act. The court, by a majority judgment, delivered, as I said, by President Saunders, allowed Mr. George's appeal. The majority states that Section 2 of the Limitation Act conferred certain squatters' rights on someone who has been in adverse possession of land for over 12 years. The majority takes the view that the law bars even a registered landowner who allows someone to squat on his land for a continuous period in excess of 12 years from bringing an action in court to recover the land from the squatter. The majority considers that the Limitation Act, which incorporated the 1833 Limitation Act of the United Kingdom, went even further to state that the squatter who enjoyed the land continuously for the statutory 12-year period had extinguished the right and title of the landowner, and the squatter thereby obtained a title that superseded that of the registered proprietor. Majority considers the historical development of land law in Dominica and notes that the TRA was enacted in Dominica about 10 years after the passage of the Limitation Act, both in the 19th century, and that in enacting the TRA, the legislature took fully into account the provisions of the Limitation Act. However, nothing in the TRA stated that it was an act to amend the Limitation Act in any way. The purpose of the TRA was merely to enact the torrent system of land ownership that had been adopted by some countries in the region. The majority noted that the indefeasibility of a certificate of title in Dominica was not absolute. This was so because the TRA expressly provided for two exceptions to such indefeasibility, the first being fraud connected with the issue of the certificate of title. Second exception, which was directly relevant to this case, was where the title of the registered proprietor had been superseded by a title acquired under the Limitation Act. The majority notes that in making this exception for adverse possession, the TRA accepted, recognized, and endorsed the notion that the ownership rights of a person with an otherwise indefeasible certificate of title may be extinguished, that is to say, supplanted or superseded by a title acquired under the Limitation Act. Where a registered proprietor such as Mr. Guye had discontinued possession of a parcel of land for a period in excess of 12 years, and a squatter such as Mr. George had been in possession for that time or more, the title of the registered proprietor suffered precisely that fate. The Limitation Act therefore precluded Mr. Guye from further asserting ownership over that land. Justice Reginald Lee, in her additional concurring opinion, observed that there was an intersection between the Limitation Act and the TRA by virtue of the definition of the term indefeasible in the first schedule of the TRA. First schedule provided a statutory exception to the concept of indefeasibility of the certificate of title without any requirement that the person making the challenge pursue or trigger the Section 33 procedure. Justice Reginald Lee stated that under Section 33, the TRA, in recognition of the ownership rights of the squatter, provided a mechanism, a procedure for formalizing those rights. The majority notes that the Court of Appeal's decision placed heavy reliance on certain remarks by Lord Jauncey of the Privy Council in the Antigua and Barbuda case of Graham Davis and Charles and others. In that case, the Privy Council interpreted the TRA to mean that A, Section 2 of the Limitation Act had implicitly been replaced or modified by Section 33 of the TRA, or that B, the consequences of Section 2 were somewhat inapplicable to registered land. The Court of Appeal followed this approach and had held that unless a squatter triggered the Section 33 procedure, adverse possession by the squatter against a registered proprietor for a period in excess of 12 years counted for naught. That a registered title being indefeasible could not be defeated merely by long adverse possession by a squatter, and that the second exception to indefeasibility was premised upon the squatter in adverse possession, first engaging Section 33 of the TRA. The majority disagrees with this analysis, and upon examination of the relevant legislative provisions and the historical case law coming out of Dominica, found that the law as it stood in Dominica was also inconsistent with the remarks made by the Privy Council in Graham Davis and another and Charles and others. That is inconsistent if it is read in a certain way. President Saunders stated that the cases emanating from Dominica examined the relationship between the Limitation Act and the TRA, recognized that the registered proprietor's title could in law be superseded by a title acquired under Section 2 of the Limitation Act. The evidential burden rested with the person claiming adverse possession to satisfy the court that he had dispossessed the registered proprietor of the disputed land for the 12-year limitation period. Section 33 of the TRA made it clear that the adverse possessor who claimed to have acquired ownership of the land under the Limitation Act could not maintain an action in regard to that land until they obtained a certificate of title in respect thereto from the registrar. Nevertheless, that adverse possessor may, by way of defense, successfully plead Section 2 of the Limitation Act to any action instituted by a person with a paper title. This was exactly the approach adopted by Mr. George in the instant case, and the court finds that the Court of Appeal was wrong in holding that Mr. George could not use his long adverse possession to shield himself from Mr. Guye's claim for possession. President Saunders concluded in any event Lord Chauncey's comments were merely obiter dicta and did not form part of the basis for the decision of the Privy Council in that case. Those comments did not support if interpreted in a certain way, did not support the actual result in that case, since by giving judgment in favor of the respondents in that case, the Privy Council was effectively affirming the notion that the rights of the squatter had prevailed in spite of the appellant's indivisible certificate of title. Both Justices Anderson and Burgess disagreed and disagree with the majority opinion. Justice Anderson was of the view that the case turned on the torrent system of land title established in Dominica by the TRA. The system was not a system of registration of title, but a system of title by registration, and was buttressed by the statutory provision that such title shall be indivisible. Torrent system was intended to aid in the stability and security of title and ensured certainty of land transactions, and more broadly, economic development. Thus, the certificate of title issued by the Registrar of Titles could not be challenged, in his view, in any other court of law, on the ground that some person other than the person named therein is the true owner of the land therein set forth. Both Justices Anderson and Burgess accepted that the TRA provided for two exceptions to indivisibility. The critical issue, however, was to determine the circumstances in which the title of the registered owner was superseded. In coming to that determination, Justice Anderson commented that it is prudent to bear in mind that as an exception to the statutory regime of indivisibility of title, supersession must be construed narrowly. This supersession occurred by virtue of a title acquired under the Limitation Act. However, Section 33 described the process by which such title acquired under the Limitation Act superseded the registered title. Justice Burgess's reasoning was on par with Justice Anderson's approach, and he stated that the dispositive issue in this appeal was encapsulated in the central question regarding whether Mr. George could invoke adverse possession as a defense pursuant to the Limitation Act, notwithstanding his non-compliance with Section 33 of the TRA. He stated that the answer to this question was in the negative. Justice Burgess, in considering Section 33, stated that the provision was an unmistakable statutory indication that the legislative intent was to retain the traditional doctrine of adverse possession as an exception to indivisibility in the title by registration system in Dominica. Section 33 laid down the procedure by which supersession was to be achieved. The minority was therefore of the opinion that the courts below were correct in holding that Mr. George's non-compliance with Section 33 meant that he could not rely on a title acquired under the Limitation Act as a defense to Mr. Guye's indivisible title. In the light of the foregoing, the court, by a majority, 3-2, allows the appeal and sets aside the orders in the courts below.
Much obliged.
Your Lordships, please.
Thank you very much. We will withdraw for another judgment, and then we will be able to. Yeah, Mr. Dutton is here.
We will be back.
So don't worry, we will be back. There's one more to go, and then we will hear your arguments.
Thank you, Mr. Dutton.
All right.